3, 2, 1, ready, start. Questions of seminal importance arising from the maintenance and welfare of Parents and Senior Citizens Act 2007 hereinafter referred to as the Act of 2007 are the subject matter of consideration of this full bench. More often than not, matters are coming up before the courts arising out of the Act of 2007 where the issue is in respect of the powers of the maintenance tribunal or oblique and appellate tribunal to pass an order of eviction of children, relative, or any third person from the property of the senior citizen oblique the parent. There were divergent views amongst the learned single judges of this court. However, what assumed significance was the fact that there were contrary division bench decisions as well. In one such matter, that is, petition bearing number 612 A-227 of 2024 Onkar Nath Gaur and another versus DM oblique President, Appellate Tribunal, Lucknow and two others, the learned single judge noticed the dichotomy in the decisions of the division benches, wherein one view expressed was that under the Act of 2007, the Maintenance Tribunal and the Appellate Tribunal do not have the power to order eviction or disposition. This view was expressed in Miss Swaraj, Varun and another versus State of UP and another 2020 11 ADJ 646 DB and Bipraji Singh versus State of UP and others. However, a later division bench took the view that an order of eviction can be passed in certain cases and circumstances in Shivani Verma versus State of UP and others 2023 6 ADJ 496 DB, wherein the court went on to overrule two other decisions of learned single judges of this court in Abhishek Tiwari versus State of UP 2022 and Khushbu Shukla versus District Magistrate Lucknow and others 2021. However, the division bench in Shivani Verma Supra did not notice the earlier two division bench cases of Miss Swaraj Varun Supra and Vibraji Singh Supra thus, noticing the sasism in the views expressed by the division benches and the variance in views expressed by several single judges in their respective decisions without considering the impact of the division bench judgments and noticing the importance of the questions involved. The learned single judge, by his order dated 15th February 2024, framed 4 questions and referred the matter to be answered by a larger bench for an authoritative pronouncement. It is in the aforesaid backdrop that the following questions have been referred for consideration of this full bench. What is the true scope and powers of the Maintenance Tribunal constituted under Section 7 of the Act of 2007, which is contained in Chapter 2 of the Act of 2007, and whether the Tribunal, in exercise of its power in context with Sections 7, 8 and 9 of the Act of 2007, would be empowered to pass an order of eviction while deciding an application preferred before in terms of Section 5 of the Act of 2007. Para. What would be the true scope and power of the district magistrate who exercises power as an appellate tribunal in terms of Sections 15 and 16 of the Act of 2016, and whether in exercise of such powers the appellate tribunal can pass an order of eviction. What is the true scope of Section 2(1) of the Act of 2007, which deals with protection of life and property of senior citizen, which is contained in Chapter 6 of the Act of 2007, and to what extent the authority can pass an order for adjudging certain transfers as void in terms of Section 23 of the Act of 2007, vis-a-vis the duties and powers of the district magistrate conferred under Rules 21 and 22 of Rules of 2014, and in this context whether the orders for eviction can be passed. Para. Whether the division bench in Miss Swaraj Burma in bracket Supra and Vipraji Singh in bracket Supra bracket close lays down correct law, or whether the law laid down by the division bench in Shivani Verma in bracket Supra bracket close lays down the correct law. Looking into the gravity of the questions referred to this full bench and its ramifications, this court, apart from hearing the learned counsel for the parties, had also invited the members of the bar to address the court on the issue before it. Sri Anurag Narayan Srivastav, learned counsel appearing for the writ petitioners, canvassed the proposition that under the Act of 2007, the authorities have the right to pass an order of eviction in befitting cases. This proposition is also supported by the learned standing counsel Sri Nishant Shukla. Another member of the bar, namely Sri Abhinav Pankaj, advocate, also supported the aforesaid proposition as canvassed by the learned counsel for the writ petitioners and the state. On the other hand, Sri Apurva Tiwari, learned member of the Oyudh Bar Association, and Sri Sudhanshu Chauhan, learned counsel, who usually appears from the Union of India, canvassed the proposition that under the Act of 2007 there is no specific power conferred on the authorities to pass any order of eviction.